But the summary is that reasonable articulable suspicion justifies brief detentions and limited searches like pat-downs, and it requires less certainty. Probable cause justifies arrests and broader searches, requires more certainty than reasonable suspicion. In essence, reasonable suspicion is enough to stop and question a person, while probable cause is necessary for arrests and more comprehensive searches. So, and I hope I'm being clear with this, in that this legal standard to stop, I can develop probable cause after I have stopped them for reasonable suspicion. I'll give you another example. Hello and welcome back to my channel. My name is Al, and I'm a retired sergeant, canine handler, and state trooper in Ohio. And what I wanted to talk today about was the distinction between probable cause and reasonable articulable suspicion, and the misconception that a lot of folks have that the legal standard for stopping folks is probable cause. That is not true. The legal standard for stopping people in the United States is reasonable articulable suspicion. I want to explain the differences between the two and circumstances and examples of what that might mean. As you can see here, the definition for probable cause, and this is according to ChatGPT, which I find a lot more detailed than using Google. If you don't use ChatGPT, you should. It's just a really great tool for looking up stuff to help you. So the definition of probable cause, according to ChatGPT, is a legal standard used in the criminal justice system that refers to the reasonable belief based on factual evidence that a crime has been committed or that specific evidence of a crime exists in a particular place. It is a threshold law enforcement officers must meet before they can make an arrest, obtain a search warrant, or carry out certain actions without a warrant, such as searching a vehicle. So an example of probable cause would be a law enforcement officer using a laser detection system or a laser speed measuring system to check for the speed of potential violators, and then using that tool as evidence that that person committed a specific crime. And then the officer would stop that person and enforce a specific law. So probable cause is more than just mere suspicion. As you can see, refer to that example that I just used with the laser. The laser was a tool used to confirm the reasonable articulable suspicion with probable cause. So probable cause is more than just mere suspicion, but does not require proof beyond a reasonable doubt. So proof beyond a reasonable doubt is the standard that would be used in court to convict somebody. So that's higher than probable cause. For example, in the context of a search, an officer must have probable cause to believe that evidence of a crime will be found in the location that they wish to search. This principle is rooted in the Fourth Amendment to the United States Constitution, which protects citizens from unreasonable searches and seizures. So, in the context of a search, an officer must have probable cause to believe that evidence of a crime will be found in the location they wish to search. So if they were swearing out a warrant to a judge, the officer would list the specific circumstances that lead them to believe that a specific crime is occurring in a specific area, and they're asking the judge to give them permission to search for those specific drugs or that specific crime in that specific area. So that's just an example of that. Now, to go to the example of reasonable articulable suspicion. So reasonable articulable suspicion is a legal standard used in criminal law, particularly in the context of police stops and searches. It refers to a situation where a law enforcement officer has specific and objective facts or circumstances that would lead a reasonable person to believe that a crime has been, is being, or is about to be committed. This standard is lower than probable cause, which is necessary for an arrest or obtaining a search warrant. So we already talked about probable cause. You have a specific crime, and you have evidence of that specific crime. So to meet the standard of reasonable suspicion, let me just highlight where I'm reading at. The officer must be able to clearly articulate the specific facts or observations that led to suspect criminal activity rather than relying on vague or unparticularized suspicion. Examples of reasonable articulable suspicion include observing someone engage in behavior typically associated with criminal activity, e.g., furtive movements near a closed store at night. So this is specific to the case of Terry versus Ohio, which, as you can see here, is a 1968 case. In which an officer in Cleveland saw somebody acting suspiciously in front of a closed business. They were walking from corner to the front of the store, back to the street corner, back to the front of the store, looking inside, acting suspiciously. So the officer that observed this behavior approached this individual. Now, to keep in mind, no crime had been committed. Nothing. They had that suspicious person that was in front of the store had not done anything illegal to that point. However, what he articulated to the court or explained to the court was that this behavior was unusual and warranted further investigation. And not only did he approach the suspect and question them, he also frisked them for weapons, and at that time found tools that were frequently used to break into stores, which they had a problem with in that area at that time in Cleveland. So the standard is reasonable suspicion to stop somebody and briefly investigate what it is that you specifically suspect. So receiving a credible, and also the second example is receiving a credible tip or information that provides specific details about a suspect or ongoing crime. An example of that would be perhaps somebody calls law enforcement and advises them that a suspect is going to be traveling through their jurisdiction that is engaged in some kind of criminal activity. Law enforcement, given those circumstances and based on how specific the information is, can investigate that by perhaps if they encounter those folks, stop them and briefly investigate whether or not this person is engaged in the activity that the caller alleges that they were. So to continue with the exam or the definition of reasonable suspicion, the concept was cemented by the United States Supreme Court in the 1968 case Terry versus Ohio, which allows police officers to stop and detain and briefly detain a person for investigatory purposes if they have reasonable suspicion. In some cases, it also permits a limited stop and frisk, pat down if the officer believes that person may be armed and dangerous, and that's exactly what I just explained. So the standard, and just to cement that, what is the legal standard for law enforcement officers to stop and detain people? The legal standard for law enforcement officers to stop and detain individuals is based on reasonable suspicion, which is established by the United States Supreme Court in the case of Terry versus Ohio. So that's just, again, it's just going to, when I asked for the legal standard for law enforcement to stop and detain, and you can look this up if you have ChatGPT as an app, explains these different standards. And then an example of reasonable suspicion is observing a person engaging in suspicious behavior in a high crime area. That's just an example. Receiving reliable tips from informants or witnesses, seeing a person match a description of a suspect in a increase in crime. If the stop leads to further evidence or information that raises the officer's suspicion to the level of probable cause, it can proceed with an arrest. So, as an example, something that happened to me in my career was I was on patrol at night, overnight, like 1 or 2 in the morning. I don't remember the specific time, but I was on the road, and I had stopped at an intersection from a county road to a state route. And that state route was a 5-lane road. There was 2 lanes going in one direction, 2 lanes going the other direction, and a turn lane in the middle. And I observed a vehicle that was approaching me while I was stopped at the stop sign, traveling westbound in the right lane. I observed that there were 2 people in the vehicle, and After the vehicle passed by, I noticed that it coasted, it slowed down, but it wasn't exceeding the speed limit when it was approaching me, but it started to slow down. So there was a change in driving behavior. I pulled out of the intersection to follow the vehicle, run the registration, make sure it was valid, and check to see whether or not there was any illegal activity happening, like driving outside their lane. Maybe they had tail lights out, license plate light out, excessive window tint, that kind of thing. So and I was a state trooper. I enforced traffic laws and equipment laws. So and certainly you're allowed to run license plates. That's why you have license plates, so they can be run. So anyway, this vehicle continued westbound on this 5-lane road. And as I continued to follow the vehicle, I ran the registration. I believe it came back valid. There was a traffic light. There was no violations. And as we approached another intersection to another state route, but that was a 2-lane road, that vehicle started to slow down, put its right turn signal on, and turned right into that intersection. I continued past the vehicle, and I made a U-turn, and there was zero traffic out. I made a U-turn, and I was going to follow the vehicle at a further distance down this state route. And as I turned and started to turn into the intersection, I noticed that the vehicle was now coming out of that state route. So it had made a U-turn itself and was just trying to lose me because they had seen me when I was in a marked patrol car. So this vehicle turned right back on the state route that we were initially on, that 5-lane road, and I made another U-turn, and I followed behind the vehicle, and then it turned into a closed carryout. The carryout was closed, and they stopped, parked, turned off their headlights, and turned off their vehicle. I passed them, and I made another U-turn, and I came back, and I stopped and outside of the premises of the carryout. I contemplated, what I should do next, and decided that I was going to call the local sheriff's office. Now, keep in mind, I'm a state trooper, and I don't have jurisdiction on private property. This carryout is private property, and at this point, I don't have a specific crime. All I have is suspicious driving, and obviously a vehicle that is avoiding me and acting weird. So I contacted the sheriff's office and reported a suspicious vehicle that I would like one of their officers to investigate. Now, they have jurisdiction on private property, and I didn't. So when the sheriff's deputy approached or arrived at my location, he parked next to me. I got out of my vehicle, and I explained what exactly had happened. And he, okay. So he went up and made contact with the individuals. And when he came back to me, he said, they're drunk. So when that was established, I had already seen them driving around. So I had reasonable suspicion based upon my explanation to the court about what it was that I saw that was suspicious to me and my experience. And I put the folks through, or the driver through field sobriety tests, arrested her for DUI, processed her, whatever. We get to court, and it's up to me to explain the reasonable articulable suspicion to the court, to the judge. Actually, I first had a pretrial with the prosecutor, explained to the prosecutor. He said, yeah, you're good. I'm of the belief that you had reasonable suspicion. So I testified before the judge. The judge ruled I had reasonable articulable suspicion. The defendant ultimately was convicted of driving under the influence. So that's just an example of reasonable articulable suspicion in which I didn't have a specific crime being committed. However, there were facts and circumstances that led me as a reasonable person and to convince a judge that a crime had or was occurring. And that specific crime was DUI. I thought they were drunk, and I confirmed my suspicion through reasonable articulable suspicion. So now getting to what the difference is between reasonable articulable suspicion and probable cause. They are both legal standards used in the U.S. to justify law enforcement actions like stops, searches, and arrests. However, they differ in the level of certainty required and the actions they allow. Now, again, you can look at all of this and read this on your own time, but the summary is that reasonable articulable suspicion justifies brief detentions and limited searches like pat-downs, and they require less certainty. Probable cause justifies arrests and broader searches, requires more certainty than reasonable suspicion. In essence, reasonable suspicion is enough to stop and question a person, while probable cause is necessary for arrests and more comprehensive searches. So, and I hope I'm being clear with this, in that this legal standard to stop, I can develop probable cause after I have stopped them for reasonable suspicion. I'll give you another example. During my career, the latter part of my career, well, actually, when I had 4 years on, I transferred over to a criminal patrol unit, which is a unit that specifically looked for drugs on the interstate. And I worked on Interstate 80 and 90. They ran together in our area. After 4 years of being on that team, I became a canine handler, and I became an interdiction officer. And I wasn't really an interdiction officer, but I was a canine handler and an interdiction officer. And so anyway, I worked on 80-90 and specifically looked for drugs during the course of my day. You know, that was my job. And while on patrol, I was traveling next to a vehicle that had a modification to the body that made it evident to me that it had a hidden compartment in it, and I could see it while driving beside it, and use that as reasonable suspicion to stop the vehicle and to investigate further. Come to find out, and used my dog around the vehicle, briefly stopped them, investigated what I suspected, looked specifically in that area once I had the vehicle stopped, confirmed my suspicion, which in having a hidden compartment in my state was illegal at the time. I'm sure it still is. And however, the question remained whether or not they were using a hidden compartment to transport illegal drugs. I then used my canine partner to investigate by walking the dog around the vehicle, and the dog positively indicated, which means it gave what is called a defined final response. It scratched at the vehicle in the area where the suspected contraband would be, near the compartment, and conducted a probable cause search and found illegal drugs, a large amount of illegal drugs. So that is another example where there was not probable cause to stop the vehicle. I didn't have a specific crime happening other than a passing, suspicion that perhaps they were involved in criminal activity. I didn't know whether or not there was drugs in it, however. Established probable cause after I made the traffic stop to briefly investigate what I suspected, and turned probable cause out of that through the canine alert. And then I also had some other reasonable suspicion with the interview where they, I'm questioning them. There's conflicting stories. There's excessive deodorizer. There's some other evidence in the vehicle that leads an experienced officer to believe that criminal activity is taking place. Helps to further cement the obligation to detain them and investigate further. If I needed to, I would get a warrant, but in that particular case, I didn't need one. So I hope that this was helpful. I hope that this dispels some misconceptions out there that police officers need probable cause to stop people. They don't. They need reasonable articulable suspicion. So look it up yourself, but it is a law of the land. So thanks for watching. Like I said, I hope it was helpful, and like and subscribe to the video if you liked the content, and hope to see you on the next video. Thanks.